The access card reader blinked red before I even finished standing up from my chair. Not yellow. Not the slow amber that means the system is processing. Solid red, immediate, like it had been waiting for me. I looked at it for a second, maybe two, and then I looked at my son-in-law across the boardroom table. He was already looking at his phone. That was the part that stuck with me, driving home on the 401 that afternoon. Not the embarrassment of it. Not the 12 people in that room who suddenly found something very interesting to study on the table in front of them. It was that he never once looked up. He'd just fired the man who built everything this company ran on, and he was checking his messages before I'd even reached the door. I want to be clear about something before I tell you the rest of this. I am not a man who holds grudges. Ask anyone who worked with me at Northgate Integrated Systems for the past 19 years. Ask my daughter, even now, even after everything. I am patient. I am methodical. Spent 2 decades building firmware architecture for avionics systems because I love the work, because there is something deeply satisfying about writing code that has to be perfect. Not good enough, not mostly reliable, but perfect, because lives depend on it. I am patient. But I am not without teeth. My name is not important. What matters is that in 1999, I was 26 years old, working out of a converted garage in Barrie, Ontario, when I wrote the first version of what would eventually become the TSX authentication protocol. It took me 3 years to get it right. 3 years of iterations, failed tests, late nights, a lot of cold Tim Hortons, and one very understanding girlfriend who later became my wife. When I finally had something I believed in, I filed for a Canadian patent through the Canadian Intellectual Property Office. Patent number 2,487,331. If I know that number, the way some men know their SIN or their childhood phone number, it's been with me that long. The patent covered a specific method of multi-layer encrypted handshaking for safety-critical embedded systems. In plain language, it was a way to make sure that when an avionics computer sent a command, the receiving system could be absolutely certain the command was legitimate. No spoofing, no injection. Just clean, verified, trusted communication between systems that had to trust each other or people died. In 2005, a man named, I'll call him my future father-in-law, because that's what he eventually became, approached me through a mutual contact in the industry. He'd started Northgate Integrated 5 years earlier, and they were building a contract with Transport Canada that required exactly the kind of authentication architecture I'd developed. We sat down over lunch at a place on Bayfield Street, and by the time the bill came, we had the outline of a licensing agreement on a paper napkin. That agreement went through 3 lawyers and 4 revisions before it was signed. I insisted on several specific clauses, the one that mattered most, Clause 17.4, for those of you who like specifics, stated that the license was tied to the ongoing employment of the original inventor in a senior technical advisory role, and that upon termination of that employment without cause, the license would revert to exclusive control of the licensor, me, after a notice period of 72 hours. My future father-in-law thought I was being paranoid. He laughed about it, actually. He said, "You're going to be family. Why would I ever fire you?" He didn't. He never did. He ran Northgate for 13 years, grew it from 40 employees to nearly 400, and treated me with respect the entire time. We disagreed about things, of course we did. We were very different people, but he always understood that the technology I'd built was the foundation the company stood on. He understood what I'd given him access to, and he was grateful. Then he had a heart attack at a golf course in Muskoka on a Tuesday morning in September, and by the following March, his son-in-law was running the company. I should have seen it coming. My daughter had been with him for 6 years. They'd married 2 years after her father promoted him into a director role. A promotion that, if I'm being honest, I had reservations about at the time, but I stayed quiet because it wasn't my company and it wasn't my marriage. He had an MBA from Queen's. He was sharp in meetings, good with clients, excellent at saying the right things to the right people. But he had never written a line of code in his life. He had never sat with a system that wasn't working and had to figure out why. He spoke about technology the way people who don't understand technology always speak about it. In terms of leverage, disruption, ecosystem, scalability. Buzzwords assembled in confident sentences that sound like knowledge until someone actually tests them. He became president and CEO 8 months after my father-in-law's death. He moved fast, I'll give him that. Within 60 days, he had brought in a new VP of engineering from a software-as-a-service company in Waterloo that made project management tools. Not avionics, not safety-critical embedded systems, project management tools. She was 31 years old and had never held a security clearance. I tried to be patient. Over the next year, I watched decisions get made that made my teeth hurt. Hardware contracts renegotiated with cheaper suppliers, testing timelines compressed to hit quarterly targets. Two of my best senior engineers, one of whom had been with me for 11 years, let go as part of a restructuring towards agility. I raised concerns, I documented concerns. I sent 3 separate memos to the board with technical specifics explaining exactly what these changes meant for system integrity. The memos were acknowledged. Nothing changed. What changed was that I started getting excluded from meetings. The VP of engineering, I'll call her that, just that, began running technical reviews without me. At first, I assumed it was scheduling. Then I found out that she'd told her team in a recorded Teams call that someone was kind enough to forward to me that I was a legacy voice who thought in architectures that didn't scale to a modern cloud-forward environment. Legacy voice. I had active contracts with the Canadian Armed Forces and the RCMP running on my architecture. I said nothing. I kept coming in, I kept doing my work. Then came the board meeting. I found out afterward that it had been planned for weeks. My daughter called me the night before, and I want to be very careful here because she is still my daughter, and whatever else happened, she was trying in her way to warn me. She said the company was going in a new direction technically, and that there might be some organizational changes. I didn't press her. Should have. The next morning I walked into that boardroom and sat down in the chair I'd sat in for over a decade. There were 12 people around the table, my son-in-law at the head, the VP of engineering to his right, the company's outside legal counsel, several board members I recognized, and a man I didn't recognize. I'd later learn he was a consultant the company had brought in from Toronto to advise on IP asset management. The presentation lasted 40 minutes. I'm not going to describe all of it. The part that matters is this. At the end, my son-in-law closed his laptop, looked at me for the first time that morning, and told me that the company was transitioning the CoreSec architecture to internal ownership and that my role was being eliminated effective immediately. I asked him to clarify what he meant by transitioning to internal ownership. He said the company's legal team had reviewed the original licensing agreement and had determined that, through the various amendments and integrations over 19 years, the technology had effectively become proprietary company IP. I put my pen down on the table. He was still talking, something about transition packages and NDA requirements and appreciation for my contributions. I said, "Have you read clause 17.4? He paused. I watched him glance at the outside legal counsel. The counsel gave a very small, tight nod that was meant to look like confidence but looked like the opposite. "Our legal team has reviewed the agreement in its entirety," he said. I picked up my things. I thanked the people in the room, the ones who deserved to be thanked, and I walked out. The access card blinked red. I drove home. My wife was at the kitchen table when I walked in. She looked at my face and didn't say anything for a moment. Then she said, "What happened?" I told her. She sat very still. Then she said, "What are you going to do?" I said, "The right thing, in the right order." The first call I made was to my patent lawyer. We'd been working together for 14 years, and when I explained what had happened, there was a silence on his end that I recognized as him shifting into a particular mode of focus. "They said they've reviewed the agreement," he said. "That's what they said." Another silence. "Send me everything tonight." I did. The second call I made was to a contact I had at the Canadian Armed Forces Procurement Office, not to complain, not to explain, just to let him know that there might be some uncertainty around the CoreSec licensing status in the coming days, and that he should keep his team informed. He asked me what kind of uncertainty. I said, "The kind that comes with a 72-hour notice period." He was quiet for a moment. Then he said, "I'll make some calls." Clause 17.4 was not ambiguous. My lawyer confirmed this within 4 hours. The company's legal team had apparently argued, in their internal review, that because I had continued to work at Northgate for 19 years and had integrated CoreSec deeply into their systems, there was an implied transfer of ownership. This is a real legal argument. It has a name. It has been made in Canadian courts before. It has also been rejected in Canadian courts before, specifically in cases where the original licensing agreement was as explicit and carefully drafted as mine was. I gave them their 72 hours. I did not call my son-in-law. I did not send a strongly worded letter. I did not do any of the things that felt satisfying to imagine. I had one conversation with my daughter, and it was hard, and I told her that I loved her and that this was not about her and that I was going to do what I had to do. She was angry. She was scared. I understood both. At 9:03 a.m. on the morning of the third day, my lawyer filed a formal notice of license revocation with Northgate's corporate address, with the Canadian Intellectual Property Office, and, this is important, with the legal offices of the 3 federal government clients whose contracts ran on CORSEC authentication. At 9:47 a.m., my contact at CAF Procurement sent me a message. It said, "Your timing is interesting. They had a board call this morning announcing an IPO timeline, TSX, listing, scheduled for Q2. I read that message sitting at my kitchen table with a cup of coffee that had gone cold. I hadn't known about the IPO. I want to be honest about that. I hadn't planned it that way. The timing was what it was because 72 hours was 72 hours. But I'd be lying if I said I didn't sit with that for a long moment. By noon, Northgate's VP of Engineering had sent an all-hands email, which was forwarded to me by 3 separate former colleagues, none of whom I'd asked, saying that there was a technical licensing matter under active resolution and that operations were continuing normally. They were not continuing normally. CORSEC authentication was embedded in every safety-critical handoff in their primary product line. The federal contracts required specific certification that the authentication protocol being used was licensed and legally current. Without that certification being current, Transport Canada couldn't approve deployment updates. Without deployment updates, the CAF contract that was due for its annual renewal couldn't proceed. The phone rang at 2:17 p.m. It was not my son-in-law. It was Northgate's outside legal counsel, the same man who had sat across the boardroom table from me and given that tight, confident little nod. He was considerably less confident on the phone. He said they wanted to open a dialogue about a path forward. I said I was open to dialogue. I gave him my lawyer's number. He sounded like a man who had expected a different response. The next call, the one that mattered, came at 4:45 p.m. from a number I recognized, my son-in-law. He didn't say hello. He said my name and then he said, "I need you to understand what's at stake here." I said, "I understand exactly what's at stake. The IPO. I know about the IPO." A long pause. "This can be fixed. We can fix this." I said, "I agree. What did you have in mind?" What he had in mind, as it emerged over the next several hours through a back and forth between our lawyers, was a reversion to something close to the original licensing terms. My continuing advisory role reinstated with a new title, Appropriate Compensation Reflecting the Actual Value of the IP, which their own IPO prospectus had implicitly acknowledged was considerable, and a formal acknowledgement in writing signed by the board that the CORSEC authentication protocol was and had always been my intellectual property. That last one took the longest to negotiate. There was a version of me, 19 years ago, who would have wanted to watch it all come down, who would have said no, revoke everything, let them explain to Transport Canada why their systems were running on invalid authentication. That version of me was 26 and had less to lose and no grandchildren. But I thought about the engineers who still worked there, the people who had nothing to do with any of this decision. 400 employees, most of them just doing their jobs. I thought about the CAF contracts and what it meant for those systems to be interrupted and what I believed about the work I'd done and why I'd done it. So I said yes. But I said yes on my terms and only my terms, and not 1 centimetre of daylight between us on what those terms were. The revised agreement was signed 46 days later. My lawyer called me when it was done. I was in the garage, of all places. Same garage in Barrie where I'd written the first version of CORSEC back in 1999. Fixing my wife's bicycle. My phone buzzed on the workbench. He said, "It's done." I said, "All of it." He said, "All of it, including the board acknowledgement." I put the phone down and looked at my hands for a minute. My wife came out to find me 20 minutes later. She said I was being very quiet and asked if everything was okay. I told her it was better than okay. The IPO went ahead. Q2 as planned, just 3 weeks later than originally scheduled. Northgate's listing on the TSX included in its prospectus a clear section on its IP licensing arrangements and the view of those arrangements. My patent was listed by number, patent 2,487,331. There's a postscript, and I want to include it because I think it matters. 4 months after the agreement was signed, I got a letter, actual paper, in an envelope, which almost nobody does anymore, from the National Research Council of Canada. They had been reviewing contributions to safety-critical authentication technology in the Canadian aerospace sector. Someone, I never found out who, had submitted CORSEC as a case study. The letter was a formal acknowledgement of significant contribution to Canadian aerospace safety infrastructure. It mentioned national security applications without getting specific, because these things don't get specific in letters. It was signed by someone with a title that took up most of a line. I have it framed in my office now. Not because I need it. I knew what the work was worth long before anyone put it on paper. But it's a good thing to look at on the mornings when I come in early, and the light is still low and the building is quiet. And I remember sitting in that boardroom watching the access card turn red, and I remember not saying anything, not reacting, just picking up my pen and thinking very clearly about Clause 17.4. The people who build the systems will always have more power than the people who manage them. That's not an opinion, that's engineering.